But these are two people, married and or not married, who have a child together
Correct.
that has special needs and may require medical care. For whatever reason, the big people don't get along now. And what I'm hearing you say is that as a father, I'm not going to make sure that the other caregiver of this child at least has some ability to get the child where it needs to go. That's what I'm hearing you say.
Court does call the case of the people versus Germond Matthews.
First Assistant Public Defender Queen Anderson, on behalf of Mr. Matthews, who's approaching. State your name for the record, Mr. Matthews.
Matthews. Thank you. You're requesting an adjournment.
Yes, Your Honor, we referred this to the investigator. I did hear Your Honor give the co-defendant June 12th.
Will that work?
That should be
fine.
fine.
The co-defendant was,
Yes, Your Honor.
all right. Probable cause conference, June 12th, 2025, 9 a.m. Bond continued.
We'll come talk to you before the stuff, okay, but call me or Monday, once you know what happens.
Court does call the case of the people versus Jennifer Jones.
Hello, Your Honor, I'm sorry. Can you hear me?
Yeah, we can hear you.
Okay, cool.
Assistant Public Defender Natalie Pate on behalf of Ms. Jones, who is present via Zoom. Ma'am, can you please state your name for the court?
Jennifer Lee Jones.
Thank you, Your Honor. At this time,
She's upside down, but that's okay.
she is, but she's here.
I don't want to lose you.
Your Honor, at this time, we would request to set this case for preliminary examination. I believe discovery is complete.
You believe, okay.
I'm sorry, Your Honor, I didn't know how to fix it.
You did not what?
I didn't know how to fix it to make me go straight.
No, you're okay. You're okay.
I'm sorry.
No, you're fine. You're fine. We'll be able to deal with it. Miss Pate is just happy you're here.
All right,
Okay.
this is my first time on Zoom.
Yeah, I wouldn't know it. You're just such a pro at it. You're doing well.
I'm upside down.
Yeah, I know. It's okay. It's okay. Will the people have their witnesses available on the 3rd or what? What's the date? Yes, the 3rd.
We'll do our best, Your Honor.
Preliminary examination in person, so you don't have to do this again. June 3rd.
Okay, I gotta go there because I live in Flint. June 3rd.
2025.
Uh-huh.
It's 9 a.m. That will be before Judge Perry.
All right, cool.
All right, yes. Your bond will continue, okay? Miss
All
Jones,
right.
you have a great day.
You have a blessed day too. Holla at you.
Bye-bye.
Thank you, Ms. Jones. Thank you, Your Honor.
All right.
Okay, so everybody else is in. Court does call the case People versus Molly Fox.
Good afternoon, Your Honor. Ellen Dennis appearing on behalf of Molly Fox.
Okay. What, Mr. We may have an issue. Go ahead. What are we doing on this? I am.
Says the court received a bond violation.
Oh,
Have you seen it, counsel?
yes, Your Honor, I have seen it.
Hold on, this hearing is about to take a sharp turn. The defense is asking the judge for another chance, but the court is about to hear something that could completely change the defendant's freedom. In bond hearings, repeated violations don't just raise eyebrows, they raise serious questions about whether a defendant can be trusted to follow court orders.
This audio was created with async.com.
She's positive for cocaine.
Right. Your Honor, when the bond was set, I wasn't actually present when the bond was set, but at that point, I think they all agreed that her major problem was that alcohol. That was why she entered a recovery program through community corrections. And she's also been attending AA. Now, she's not been positive for, as I understand it, she's not been positive for alcohol use since that time. This cocaine use is kind of, I don't know, an anomaly. And it seems from my discussion with my client, it's kind of situational, and she realizes that this is absolutely
We
unacceptable.
had another anomaly back in March.
Right, I understand. But what I mean is, it's not, unlike the alcohol, it was not the dominant problem. And yet it is a problem, of course, but it stems, I'm told, from a friendship that she has with somebody that she's had for many, many years. And apparently this other person got into cocaine use, and she would sometimes participate when she was with that person. She realizes she has to break off all contact with this friend because it's apparently evolved into a relationship in which cocaine is customarily used. So we would ask, of course, that bond be continued, and if court thought it was appropriate, she could be put on a tether. She has been going to, she had 8 weeks of first phase recovery program, and she'd started the second phase prior to this cocaine use. And she also has been going to AA once a week in addition. So the recovery program, I guess I would have to say, has been partially successful. And we would like to have an opportunity for her to continue to work on her recovery through that. And I know Mr. Kennedy and I have talked about possibility of resolving the case through recovery court, but he's not sure that she's eligible. And I've been waiting to find out if that's true, because that might very well be a good resolution. So, and in the meantime, I mean, she is the caregiver for three minor children, ages 13, 10, and 5. They're all her children. And her significant other with whom she lives, he works full time for one of the car companies, I forget which, for Ford, and is gone in the daytime. So caring for the children, especially when school gets out, which will be pretty soon now, would be very difficult without her presence. But so of course, we're asking for bond to be continued or possibly be modified to provide for her to have an alcohol drug tether. I might also say, I think my understanding is that she entered the recovery program voluntarily. That was not a bond condition. Is that correct? It wasn't. She says it was not. So she is she's attempting to do recovery on her own, but of course, community corrections made it possible for her.
Violation with cocaine.
I'm sorry?
This is her third violation with cocaine.
Apparently so.
Yeah, that's a problem.
It is a problem, and but I think a tether would definitely take care of that problem.
I don't have a tether that reads cocaine.
Well, that's what I wasn't sure when she suggested it, whether that was feasible. She seemed to think it was, but I don't know.
She who?
My client.
Of course. She's going to tell you that, and then she's going to go out and use cocaine.
Well, maybe she just doesn't know. I didn't know.
She does what drug addicts do, and they tell you something that's not true.
Well, I don't know that she's truly an addict because her use has not been that frequent. But at any rate, I totally agree with the court that she can't be using cocaine, and I think she also agrees, and she understands.
At what point did that dawn on her?
I'm sorry?
At what point did that dawn on her? When we ordered that she couldn't use illegal drugs? In January when she tested positive? In March when she tested positive? Or this time when she tested positive? Which point did she all of a sudden figure out she can't use it?
Well, she should have figured it out beforehand, Your Honor, but she now tells me she has figured it out, I guess you could say.
I always hate asking, but I'll ask. Why not? I'll bite. What this time made her figure it out?
Well, maybe she's come to a realization that it's not a good thing for her. I mean, she's brought it up in the group sessions that she's had, these weekly group sessions, and I think they've convinced her that she has to cease her friendship with her old friend because obviously it's not a friendship that's.
And there it is, the consequence every defense attorney hopes to avoid. Bond revocation means the judge no longer believes the defendant can safely remain out of custody while the case is pending. This isn't a conviction, but it's a powerful reminder that ignoring court conditions can have immediate consequences. Do you think the judge made the right call here?
This audio was created with async.com.
Furthering her best interests. And she tells me that she is going to do that. So I hope that she has come to the realization of how damaging to herself that this is.
I'm going to adjourn the probable cause conference in this case to June 5th, 2025, 9 a.m. Because of her violation, defendant's bond is revoked, defendant is remanded.
Thank you, Your Honor. That's it for me today, Your Honor.
Take care.
Yeah.
Happy birthday.
Thanks, sir.
Court does call the case of the People versus Jerome Burns.
And Assistant Public Defender, Matthew Carey, I can rule, Your Honor. Sorry. On behalf of Mr. Jerome Bird.
How is it, Ms. Akinruli, that there are times I never hear from you, and then I have the extreme pleasure of starting out with Mackie and then you?
It's your lucky day, Judge.
Is that?
Yes, it
You
is.
call it luck? Okay, go ahead. Oh, well, yeah, come on. The people's motion, this was discussed this morning regarding access to the premises.
Yes, Your Honor, I did send that motion to the court and the council. Since then, council and I have been speaking. It's my understanding that the apartment is actually leased to defendant's father and I believe his mother potentially. I don't believe the victim is on that lease, even though that was her home and that was her residence. I wanted to forward that information to the court. I don't believe that we are in a position to ask, for her to be able to stay in that residence since she's not on the lease and it is the defendant's father who is.
Well, I think we're absolutely in that position. I mean, that would occur, that occurs all the time.
Well,
And the problem that I have with not being able to do it, or at least forcing it to happen, is that you would have individuals that may be potentially victims of, in a domestic violence situation, where the leased premises, which is their home, is leased to somebody else. And then they can't go back there. And they didn't do anything to be sort of on the outs.
Judge, if I may, I think there's a little bit more information that the court should have.
Okay.
My understanding, my client's father is here present, and he was the one that was able to update us on what was happening. The apartment is leased to him and his wife. That has been their home for the past 9 years.
Who's home?
Father and mother, not defendant and complaining witness.
Okay.
Yes, so it's leased to them, but that's their home. And my client and his wife were living with them at the time. They still live in the home currently.
Okay.
And my understanding as well, and it states it in the report, before this incident even occurred, the complaining witness had left the home. She had already moved out of the home. I know that the original allegation or issue was that there was the locks in the home were changed.
Yes, that's what I heard.
That is correct.
Why I set the hearing.
I spoke with Dad about that, and Dad said, yes, I did change the locks because she had since moved out the home probably about a month before then. And later he found out that the complaining witness was.
Watch the direction of this hearing carefully. What started as a dispute over property is now becoming something much bigger. The judge's attention is shifting toward the welfare of a child with serious medical needs, and when that happens, legal technicalities often take a back seat to immediate safety concerns.
This audio was created with async.com.
Entering the home with the keys that she did have while he wasn't home, moving things around. And he stated that he felt it was necessary to change the locks because she was no longer living there.
Your Honor, my understanding is that the victim left because of the physical abuse and fear by the defendant. So she left and sought a safe place for her and the child. So that part's true. My understanding is the same, that she left, however, under those conditions, and I think that is an important addition. But going back to why I don't believe we cannot exclude defendant's father from a place where he's policing, of course. So in regards to that matter, we'll just ask for there to be a civil standby so she still has belongings there. I of course ask that none of her belongings be touched by the defendant's family, and that they cooperate with law enforcement to allow her to come and retrieve those. There's also a matter of the vehicle. So at this point, the concern I have for this victim, and more so for the child, quite frank, is that this child has very serious medical needs. This sexual assault took place at Mott's Children's Hospital. While their child was in the hospital, the defendant sexually assaulted the victim. This victim is in fear of the defendant. She, as far as I know, does not have a home to go to. She, as far as I know, does not have a vehicle for transportation. And we're not just talking about going to get groceries. She has a child who has serious medical needs. And so it's concerning to me that she is not able to take that child where that child needs to go for medical needs and other basic necessities. So she's, of course, in a very, very bad situation. The two of them are married. There is a car that is, from what I understand, just sitting there, and there are car keys that go to that car. Counsel and I have been speaking throughout the day, and I thought we had an agreement that the victim could use the car since it's just sitting there, and she desperately needs it for they have in common, to be able to do what she needs to do for that child. Since then, I learned that the defendant is not agreeing to that. My understanding is that he has some concerns about the condition of the car, and I'll let Ms. Akruli speak to that. But again, my more immediate concern is this child right now. I'm not suggesting we should talk about the ownership of the car, but I don't understand why this victim cannot have access to their joint car to transport the child if she needs to.
And Your Honor, I did have an opportunity to speak with my client. Initially, the client's father, again, was the one who was able to facilitate. He did inform me where the vehicle is, that there are keys to the vehicle. And speaking, he doesn't have permission to give them over, obviously. I spoke with my client. He reports that there is front end, it's not damage, but there are front end issues with the vehicle. It's a work truck. It's a very large truck. It's a Chevy equivalent to, I think, a Ford 350. It does.
That statement changes the entire atmosphere of the courtroom. The judge isn't simply debating ownership of a truck anymore, he's challenging the father's sense of responsibility. Sometimes one question from the bench carries more weight than 10 minutes of legal arguments. Did you notice how everyone suddenly became much more careful with their words?
This audio was created with async.com.
Doesn't have any of the additional enhancements, but he said it's a very large truck. All of his work stuff is in there. He's concerned.
His work, dad's or
my client, Your Honor. This is his vehicle. He reports that this vehicle was his prior to. He does not feel that it's
prior
safe.
to
Marriage, I apologize, because the people indicated that this is like joint marital property or something to that effect. But this is a work van or truck that he has been using for his construction business. I do not think when she left the home, she left without the truck. Judge. The truck has only become an issue now. And I don't really understand how, if there is an emergency, the truck would really be of any help, because I think 911 would be the more plausible way to go if there's a medical emergency with the sick child. Back to the truck though, Judge. The truck, we don't know.
I guess I don't get this. I mean, I'll let you finish.
Sure.
But these are two people, married and or not married, who have a child together
Correct.
that has special needs and may require medical care.
Mm-hmm.
For whatever reason, the big people don't get along now. And what I'm hearing you say is that as a father, I'm not going to make sure that the other caregiver of this child at least has some ability to get the child where it needs to go. That's what I'm hearing you say.
This hearing has clearly shifted beyond a routine procedural argument. The judge is no longer focused only on property ownership or technical legal rights. He's weighing the practical impact of these decisions on a vulnerable child with serious medical needs. In criminal courts, especially in domestic violence cases, judges often consider victim safety and access to essential resources while criminal charges are pending. Notice how every explanation about the truck's ownership or insurance keeps running into the same question: how is the child supposed to get medical care? That's a powerful reminder that courtroom decisions aren't always just about who's legally correct. They're also about protecting people while the legal process unfolds. What do you think? Should the court prioritize immediate family needs in situations like this, even if ownership disputes remain unresolved?
That's not necessarily what we're saying, Judge. I think that my client, again, with the mechanical issues with the vehicle, he indicated that it's not safe for her to drive. So it's not the safest vehicle to turn to if you needed anything in regards to transportation. And also, if he was in the process of getting the condition or the issue of the car fixed, and he hasn't been able to do that. So it's possible that driving it any further would possibly make it, put the car in a worse condition mechanically. What else to do?
So, Your Honor, if I may.
Yeah.
I'm not here to argue the condition of the car. Just I understand this is all coming to the defendant. Again, and I want to be very clear that the victim has not asked for access to the car. I reviewed the case. I found that she does not have any transportation, and based on my experience, that is concerning to me when there is a sick child. How that car may be affected, potentially or not, by her driving it to provide for the sick child doesn't really matter. That is not what matters here today. This is an urgent situation. It's bad enough that she is homeless because of the physical assault she endured while having a sick child. The least we can do is give her access to the car for those purposes, and then they can work it out later. I'm not worried about whatever's going on between the two of them. She needs to be able to have some transportation. She has a small child that is sick, and she needs some help.
And Your Honor, my client, he did raise his hand. He just wants the court to understand that he's not trying to keep the vehicle from them. He says it's not a safe car to drive at all. That normally when the child has appointments, the state provides transportation for the child to get to and from his appointments. He has indicated to me that he has transported the child in their vehicle previously, but the wife does not normally drive that vehicle. It's not a vehicle that she's used to driving. She doesn't drive it normally. It's his work truck. And aside from...
So she's incapable of handling what would be...
No, I don't know.
350?
I don't know if she's licensed. I don't know if she's insured on that vehicle. I don't know. She's not. They're just...
Not insured?
She's not insured on the vehicle, Judge, according to what my client just told me.
How does that happen?
It's a joint insurance. So if I would have added her to the insurance, then she'd be able to legally drive that vehicle. If she's not added to the insurance, she legally cannot drive that vehicle.
That's not what he's asking you. Why did he
Your wife?
Do it.
Why did
Really?
insure her in the
And it cost way too much money having her insured on that vehicle.
And that's my understanding, Your Honor.
Was there a vehicle she was insured on?
When her dad had a vehicle for her. She was insured on that and had received a.
Where's that vehicle then?
That was 7 years ago.
This is a textbook example of judicial discretion. The judge isn't deciding who permanently owns the vehicle. That issue belongs somewhere else. Instead, he's making a temporary decision aimed at protecting the family's immediate needs while the criminal case moves forward. It's a reminder that courts often balance practical realities with strict legal procedure.
This audio was created with async.com.
Sure.
And that's
So for 7 years, she hasn't been able to drive?
She's able to drive. She just hasn't, she chose not to.
and that's kind of what Dad told me, Your Honor. Dad just says he doesn't really know her to drive. She's not one that drives normally. She's usually at the house, or they use the transportation provided by the state whenever they needed to take the child to the vehicle. Other than that, my client was the one who would do the majority of the driving.
Your Honor, what we're seeing, I'm sorry, this is a perfect example of the worst domestic violence dynamic you could possibly imagine. The fact that the defendant and the defendant's father are deciding whether or not this victim can drive a vehicle, when she can drive, how can she, I mean, this is.
I don't think that that's what we're saying, Judge. We're just stating facts that he stated that she had a vehicle at one point. She no longer has a vehicle. If she doesn't have a job to go to and she doesn't have any other need to drive, all we're stating is that she does not drive normally. The bottom line on our position, Your Honor, is my client indicates that the vehicle is not safe. Now, we've concluded from him that she's not insured on the vehicle. I don't know the status of her driver's license. So honestly, I think that this is a family law issue. I don't think that this pertains to our case at all. She left the home previously before this case happened.
I want the keys turned over.
You want the keys? No worries, sir.
I want her given access to the truck. She can then make, I'm assuming she's a grown.
Cases like this show that courtroom hearings are rarely black and white. Every decision requires balancing legal rights, public safety, and the real-life impact on families caught in the middle. Now it's your turn. If you were the judge, would you have handled this situation differently? Share your thoughts in the comments, and let's discuss it.
This audio was created with async.com.
So she can make her own decision as to whether or not she wishes to drive that truck.
Okay.
She can also make her own inquiries as to the insurance that's available on that truck. And the like. She can even take it to a mechanic and have them look at it as to its roadworthiness. But she's grown and she can make her own decisions and doesn't have to have defendant dad make those decisions for her.
So how are we going to get these keys to her?
Dad says he has the keys. It's not with him right now, but I mean, previously, again.
Them to the public defender's office can get them to the prosecutor's office can get them to the victim. All right. What do we then need to do on this case?
So, Your Honor, initially we were asking for the adjournment. There was a little bit more discovery or investigation, I would say, on our end that we needed to complete before we decided which way to go.
About the 5th or the 12th, counsel?
I didn't hear you, Your Honor.
5th or the 12th?
Let's do the.
I mean, he's in custody, that's why I'm asking.
Let's do the 5th, Judge, that's fine.
June 5th, 2025.
This was a fascinating example of how a preliminary court hearing can evolve into a discussion about real-life consequences rather than simply legal paperwork. The judge ultimately left the criminal case on track with an adjournment and continued bond, but he also made it clear that the alleged victim should have the opportunity to make her own decisions regarding transportation instead of having others make them for her. Importantly, this was not a final ruling on ownership of the vehicle or the underlying criminal allegations. It was a temporary decision intended to address immediate concerns while the case continues through the Michigan court system. These early hearings often focus on balancing defendants' rights, victim protection, and practical necessities before any determination of guilt is ever made. Cases like this show just how much judicial discretion can shape the proceedings long before a trial begins. If this courtroom exchange caught your attention, let us know your thoughts in the comments below. Do you agree with the judge's reasoning? And if you enjoy real courtroom breakdowns with expert legal insight, don't forget to like this video, share it with others who love courtroom drama, and subscribe to the channel so you never miss another compelling case.